Tonight on the Daily Debrief, a Pennsylvania rapper wins a new trial after convincing an appeals court the police botched his case. Also, the case of a man accused of killing his family when they interfered with his relationship with a Bulgarian webcam model. And
Nicole Nachman is and was a broken individual.
A Florida woman raises an insanity defense after shooting and killing her mother and stepfather. Plus, accident or murder. Defense experts say a 2-year-old's injuries were caused by life-saving treatment, not abuse from her own parents. The Daily Debrief recaps the day in court. It's Thursday, July 25th.
Welcome to the Debrief, everybody. Good to see you. Good to see Brian Buckmire here along with me. How are you?
Good. Yourself?
I'm very well. Let's get to the news here. Convicted pedophile and accused millionaire sex trafficker Jeffrey Epstein found injured in his New York jail cell. Chief investigative correspondent Brian Ross explains the possibilities as to how this happened from the newsroom. Brian.
Well, good afternoon, Aaron. According to authorities, Epstein was found in a fetal position in medical distress in his cell with some sort of bruises on his neck. It's not quite clear. 3 possibilities, Aaron. Was it a suicide attempt, which the New York Times says it's being treated as? Was it an attempt to get out of the cell into a hospital? He was taken to a hospital, has since been returned. Or was there an attack on Epstein by another inmate inside the Metropolitan Correctional Center, where he's in a special housing unit, which seems unlikely because, for the most part, prisoners in that unit are kept in solitary confinement. So the Bureau of Prisons is not providing any more details, and right now it's all speculation as to what happened, but apparently he is back in good health and back in his cell in the Metropolitan Correctional Center. Aaron?
Brian, any sense of when we might have additional answers as to exactly what did happen here?
I think the information will come mostly from his lawyers, and so far they're not commenting.
Very good. Brian Ross reporting from the newsroom tonight. The rapper known as Meek Mill has won a case for a new trial in Pennsylvania. A judge convicted the rapper, whose real name is Robert Williams, of drug and gun offenses in 2007. The conviction was based on the testimony of one police officer. That officer had stolen money and lied about it before the rapper's arrest, but it wasn't caught until later. A second officer contradicted the first officer's account of what happened with Mills, and a third admitted to engaging in corruption with the first officer. That's why 3 Pennsylvania Superior Court judges agreed unanimously that this after-discovered evidence is of such a strong nature and character that a different verdict will likely result at a retrial. And with reference to the officer suspected of lying, the Commonwealth now states it cannot call a witness whose credibility it mistrusts. Those words in the court decision. Criminal defense attorney Brian Buckmire is here early with us tonight. So, Brian, it sounds to me like this case is dead, even though the prosecutor's official statement is, well, we're reviewing the decision.
I mean, it's absolutely dead. If you look at some of the stipulations that are actually in the motion here, there's 11 stipulations. They're saying the credibility of the witness, the information that was given, the fact that it was one sole witness testifying against them. They're saying they're not going to go forward on this type of witness. Now, typically when you bring it back to the lower court, it's for the lower court to decide whether or not to retrial the case. The prosecutor says yay or nay, and we go from there. But with the stipulations that they gave that actually lowered the burden for them to have this retrial, I can't fathom why Krasner would do that.
Yeah, I mean, the state's basically saying, forget it. We're throwing our hands up and saying we just can't do anything at this point. Let's back this up, though. The defendant wanted a new trial. The Commonwealth agreed to a new trial. So why did the first judge who looked at this say no to them both? What was really at issue here?
So I think what it is some of the standards in which you're looking at. The one that I think that the new court really drove home on was that it's not just about impeachment of the witness. It's actually that this information can go beyond that. You did highlight one of the standards by which you get a new trial, that being a different outcome, but it can't just be solely for the purpose of impeachment, that new information. And this judge said, hey, that rises above the level, and this lower court was wrong.
Okay, so it seems to be very certain that there's not going to be another trial here. Let's assume maybe that less than 1% chance occurs and there is a new trial. It's interesting that the appeals court said there's going to have to be a new judge on any new possible trial. So that caught another issue right out of this right there. No perceived appearance of impropriety if there is a new trial.
I mean, that's what courts are big with. It's about perception over reality. They want to at least give the perception that justice is going to occur, and hopefully that we as citizens can look at it and say the reality is that justice will be given. But I think you're more likely to get a Meek Mill's mixtape than you will get a new trial.
I agree. So chances are case closed for this particular defendant. Brian, we'll see you again in a couple of minutes here. Day 2 of the trial of a Florida man accused of killing his family after he stole their money and sent it to a Bulgarian webcam model. 29-year-old Grant Amato is accused of sending the woman about $200,000 from his mother Margaret, his father Chad, and his brother Cody, so that she would keep talking to him. When his parents intervened and tried to shut down the so-called relationship, prosecutors say the defendant seen there murdered his family and then tried to cash in their life insurance policies. Prosecutors say the webcam woman, known only as Sylvia, was the defendant's obsession. No one knows if Sylvia is even that woman's real name. A crime scene analyst testified that she believed the body of victim Chad Amato had been moved.
When I first saw Chad's body in the kitchen, I asked the investigators if he had been moved. It was my instinct that he was not in the correct position or in the position that he had died in. Based on my training and experience, his taking in the entire crime scene, the blood patterns, the movement in the blood in the kitchen, it seemed that he was not in the same positioning as he would have been at the time he died.
And of course, the state accusing the defendant of moving his brother's body to try to make it look like his brother was the perpetrator of the shootings. And now to day 2 of the trial of a Florida woman who says voices in her head led her to kill her mother and stepfather. Nicole Nachman is raising an insanity defense involving schizophrenia. She's also raising battered child syndrome as self-defense, saying she was beaten and finally snapped back. Nachman confessed that she drove home from Florida State University, shot both of the victims, and then drove back to college. The state says Nachman set a trap for her mother, Miriam, using her stepfather, Robert's email address.
She discovers that Miriam Lear, who's in Jacksonville, is trying to reach Robert through email on his Yahoo account. And she's telling him, I'm trying to reach you. I'm trying to call you. What's going on? Why aren't you responding? And Nicole Nachman captured that email on her phone. And you're going to hear how she tried to access that Yahoo account, how she tried to change the password on Robert's Yahoo account, all while he's laying dead in an adjoining room. You see, ladies and gentlemen, for this trap to work, the mom could not know she was home. In order to kill her mom, she needed to surprise her mom. She needed Robert out of the way so he couldn't protect her, and she needed her mom to be completely unsuspecting.
The defense said the shooting was the result of a mental health episode and family trauma.
She's broken because she was a biologically vulnerable child who lived in chronic turmoil and instability. Nicole Nachman's childhood was marked not by a contested type of atmosphere, but by a warlike custody battle from the inception. Her brother, Joseph Carey Jr., was in fact the person that Nicole was closest to. Joseph Carey Jr. chose to leave his mother's home because of the abusive and instability of his home life with both his biological father, Joseph Carey Sr., and his mother. You will learn that the loss of these support systems has an impact on ultimately where Nicole Nachman is today.
The first witness on the stand was the person who placed one 911 call after hearing shots ring out, and then a second call after seeing one of the bodies.
You have an emergency?
Yes, it sounded like gunshots outside of our house, and I saw somebody screaming and running.
And you heard gunshots and screaming?
It sounded like gunshots.
How many gunshots did you hear?
It was 2 or 3.
Did you hear anything else after that, after the shot?
I heard somebody screaming. It looked like somebody running.
Okay, do you know if anyone was actually hit?
I don't know. I didn't go outside.
911, what is your emergency?
Yes, I called earlier about gunshots at my house, and it looks like I'm looking out the front yard. It looks like somebody at the end of our driveway got shot or something. They're like laying on the ground. Can we get a deputy here now?
Yes, sir. I'm trying to enter this into the system. How long ago were the gunshots?
I don't know. I called earlier. It was about 4 minutes before I called earlier. I think a deputy's here now.
They are there. Can you see them?
I think so. I don't want to go outside after I heard this. It looks like there might be something. I can't really tell. There might be a body on the ground out here.
Can you see? Are you window of the deputy there?
Yeah, I can see the deputy there. I think he's going to check the body.
The neighbor who placed that call testified about what he saw.
We heard a pop, and then I heard a pop pop. It almost sounded like fireworks. And I was kind of thinking maybe, you know, there were some kind of kids outside, you know, doing fireworks or goofing off or something. So I didn't know exactly what it was. I basically walked out to our living room to see what was going on, and I kind of heard like a scream. It wasn't a kid's scream, it was kind of scream of, you know, agony or disbelief. And next thing I saw was a shadowy figure run between the two windows in our living room towards back to that lake. When I went out to the living room and saw the shadowy figure run, that's kind of, I think I really got startled and thought something might be up.
And still ahead tonight here on The Debrief, we head back to the case of a husband and wife accused of murdering their foster child. Defense experts are directly refuting claims by the state that the victim's injuries were the result of abuse. We break down that testimony in just a moment. Day 3 of the defense case in the trial of a Georgia couple whose 2-year-old foster daughter died in their care. Joseph and Jennifer Rosenbaum face a mix of murder and other charges over the death of Layla Marie Daniel. The defendants say the little girl died accidentally by choking on a piece of chicken and that she was further injured during CPR. The state says Layla likely had been having a seizure triggered by abuse. One of the state's key witnesses has been the victim's sister, Millie. She testified that defendant Jennifer Rosenbaum was abusive. The defense has called several witnesses to testify that Millie was coached and was probably lying.
Yeah, I would say yes. I would not say that it was a problem where Miss Amanda could not correct that, but I would say that she would have stories that she would tell, and they may have been, for her age, it might have been fabricated some. Mm-hmm.
And Samantha Harold is the lady that eventually adopted.
Yes, yes, ma'am.
Mm-hmm. Two sisters.
That's correct.
And did Ms. Harold ever express any concern about not knowing whether Millie was telling something that was truthful versus something that was fictional?
Yes, there will be times that Millie may tell a story or say something, and we would question it because of the time frame or who she was referencing, but it was concerning, and we talked about it, and it was probably addressed during counseling, but it was not a behavior where we thought that it was detrimental. It was something that we needed to correct.
The defense called an expert who testified that the authorities botched their interview with Millie, the sister. That expert said the interview was done in a crowded situation, which would have been confusing for a little girl, that the interrogators didn't pay enough attention to nonverbal cues, and this.
What about leading questions? Is that a problem in child interview?
Very clearly, that's a problem, because if you do leading questions, you're giving the child a hint as to what the answer is. With high-value people, an officer, a defects worker, somebody that the child knows is important, they've got to be extra careful, because the child's going to pick up on what they want and give it to them. That makes school teaching better, because school teachers know that, and they sort of hint to the kids what they need to be saying, learning, doing. But that's not what we're doing in forensic interviewing. We want the child to say what they have directly experienced and know.
If a child before could not be coached, what would that say about our pre-K system, not kindergarten system.
We'd have to close it down and save taxpayers a lot of money, because if they can't be coached, they can't be taught, they can't learn, and we're wasting time trying to teach them. That's absurd.
Another witness continued the theory that the victim's sister, Millie, was prone to lying.
Did you and Miss Harrell encounter any problems with Millie? Was lying a problem?
That was one of the issues, defiance, not doing what you're told, maybe being told to do something, clean up your room, and then saying that you had. A lot of children do that. Mm-hmm. So I think out of the 44 sessions, 3 of the sessions were directly related to maybe a lie that Millie had been caught in.
Was Millie getting in trouble in school for lying?
She did on, I know of 2 occasions.
Her adoptive mother, did she have any concern about Millie's memories?
I think one particular incident I remember, Millie, we were preparing to do a memory box. So I was talking to Millie about, these are the things you need to collect for your memory box, things to put in, to remember her sister. And Millie had brought out several photo albums, and she was going through it, talking about various biological family members. And I think Amanda was just a little concerned about her not fantasies, but she embellished the past. She said, she goes, I'm not sure all that's true.
And then after that, the parade of friends and family members continued. They have all said that they never saw bruises on the victim or her sister, and that Jennifer and Joseph Rosenbaum, the defendants, were people they trusted.
Do you recall the time when Layla passed away?
Yes.
And did you have an opportunity to see Jennifer shortly thereafter?
Yes, I did.
And what was her demeanor?
She was very upset. We actually cried together.
And normally, what is her demeanor?
I had never seen her so broken.
But normally, what is her demeanor?
She's very well put together, can carry the weight of the world on her shoulders, but this had broken her.
The state has forced many of these witnesses to eat their words on cross-examination. Take this friend who stuck up for the defendants. She was asked about defendant Jennifer Rosenbaum's claim that all she did to the victim was try to save her from choking.
Did you hear anything about choking?
Sure, on the news.
Okay. Would you expect someone to perform the Heimlich maneuver in the vaginal area?
On a child, on an infant, the way you hold an infant, well, I'm not an expert in the Heimlich maneuver on infants, but I don't know it's the same way. I think you bend the child over your arm, so I don't specifically know your arm's supposed to go up and through the legs, but once again, I'm not certified in the Heimlich maneuver, so I don't know.
So you think you would see States Exhibit 53 from the Heimlich maneuver?
I can't tell you the answer to that.
You're friends with Jennifer, are you not?
I am.
Did you see the injuries that you see on States Exhibit 67?
On
Layla, the day that you saw her?
No.
Did you see that part of her body?
No.
And would that have concerned you?
If I saw it that day, yes.
Would you agree with me that the sections of the body that we've seen here in court today are sections that would have been covered by clothing?
More likely.
The state is sticking to its theory that the injuries resulted from abuse. The defense predictably called a doctor to refute that theory.
Well, in my opinion, Layla Daniels sustained a multiplicity of injuries, both on the outside of her body, various bruises and scrapes in a lot of different places, but internally also there was evidence of injury involving the pancreas and the liver and the diaphragm. After looking at all of that and looking at everything under the microscope, and then, of course, seeing her statement and then visiting her house and actually what I've had her having her demonstrate to me to show me what she did. That was my instruction. Just show me what happened. My conclusion was that all of these injuries were sustained during a very, very panicked, frenzied attempt to try to save Layla's life after she appears to have choked on some chicken that she had stuck in her throat.
The sister of defendant Jennifer Rosenbaum testified about one possible cause of the victim's injuries. Several witnesses have described the victim as a spirited or perhaps clumsy little girl who was frequently bumping into things or otherwise being hurt.
Millie and Layla were playing outside, and Jennifer and I happened to look up, and Layla and Millie were on a ladder that was like going up a tree. And I think when Jennifer and I kind of jumped out the door and were like, "Girls, what are you doing?" they got startled, and Millie fell down, and it caused Layla to kind of fall off the ladder as well.
Was Millie hurt?
Of course, they were crying, so Jennifer and I went out there and got them and brought them back in the house. Millie was saying that she hurt, so we took her clothes off of her. We looked over her, and we noticed some redness on her hip and like her side area. She was holding on to the ladder, like kind of looking back down at Layla to see how high Layla was off of the ground. And I guess when she fell, it kind of got her side area. So we did notice that there was a good bit of redness, and we even had a discussion with her that, you know, she was probably going to have a bruise the next day.
Back to Brian Buckmire for analysis on this case. So Brian, I'm watching witness after witness after witness after witness for the defense here. They have a lot of witnesses in this case, and they're basically all saying the same thing. This girl was prone to bumping into things, okay, that they all trusted the defendants, and that the sister is probably lying about things. I'm counting at least 4 witnesses saying that. That takes guts to get up there and accuse the young sister of, who's said to be a victim in this case, of lying.
Well, I mean, children lie. I mean, I'm sure if you asked our parents, maybe they would say otherwise, but children at a young age can maybe not always lie because they can't appreciate what a lie is, but they can fudge up the truth, little white lie here, exaggerate here or there.
Or be coached.
Or be coached, and that's what children tend to do, and that could have been the situation here, so we don't know whether or not their testimony is truly truthful.
Is this enough for the defense to inject reasonable doubt into this case? I'm sitting here at this point, and I thought this was a strong case for the state. I'm wondering now. I'm not sure where I come down on it, but I'm really starting to wonder.
I think what the defense needs to do is to say that feeling that you're getting across to the viewers right now, that means not guilty. You need to explain to people that feeling is reasonable doubt, and that's why you should come back with not guilty.
You know, what if it was a legitimate injury from this ladder? What if it was further injuries caused by CPR? What if the defendant thought that the victim was choking and was really having a seizure like the state claims? If it's what ifs, it's not guilty. That's how you would do it.
Yes.
Exactly. Okay, Brian Buckmire, a simple yes, one-word answer. Great to have you here as always.
Thank you. Glad to be here.
Let's wrap up the debrief. It's that time of the evening. We'll be back here at 5 p.m. with our recap of cases nationwide. And of course, live trial coverage of these cases begins at 9 a.m.